motion to compel the standards is to obtain discovery that has not been given to us. In any scientific case, and as Your Honor probably has read recently, there was a large report by the National Academy of Sciences dealing with forensic science in any courtroom. But in any scientific case, it's not the reports that are important to a defendant. It is the procedures, the processes, the notes, the guidelines, the standards that the scientists use in terms of coming to a conclusion. To just have a report is like going to the movie theater, buying a ticket, and then saying you saw the movie because you have the ticket. You have to go in and see the movie. For instance, in DNA, I was just in Tennessee, and as a matter of practice, the FBI gives you the discovery, the bench notes for the DNA, because you have to be able to see how much DNA was quantified, whether there may be other DNA that they didn't pick up, whether the levels that they use are important, and that would be toward the number 7 in our bench notes. So they normally give you what's called an ABI 310 program that has all the scans, the runs. They normally give you what's called the GenoScan interpretation, the genotype of files, and we have none of that with regard to the DNA bench notes.
Well, my general response is, again, this is the second time I believe that we have discussed this issue, and I think the last time was maybe back in October or before. I indicated to the court, again, that none of these materials are in the state's possession. They're in fact not within the physical boundaries of the state of Florida. They are in fact in the possession of organizations outside the state of Florida, over which this court, with all due respect, has no jurisdiction. I did suggest to counsel at that time, and I don't know if present counsel, I don't think was in the case at that point, that they should contact the general counsel for the organizations involved to see what they would give them voluntarily. And, apparently that was not done. The organizations, in fact, were not, as far as I am aware, even supplied with a copy of this motion. I do understand that Dr. Voss at Oak Ridge did get a copy of the notice of hearing, but not a copy of the motion. However, in order to facilitate this, I went out and found out who it is that they would need to contact for the Oak Ridge Laboratory and for the FBI. And at this time, I'm handing counsel the names and phone numbers of general counsel for the FBI.
I have the general counsel, Your Honor. I'd like to respond.
And for general counsel at UT Patel. The items that the defense is requesting, I don't have. You don't have the jurisdiction to order them to produce, and the state is under no legal obligation to go out and obtain documents for the defense.